I'm Cliff Ribner, and I'm going to talk to you about some of the mechanisms that politicians in Washington, that's where they are primarily, have been using over the years to get power over us. When our founders founded this country, they were very careful to define the entire federal government in a written document that we created, the citizens. It's actually signed. It's the Constitution, besides being the supreme law of the land, is a contract. Very important. There was a pre-existing law of contracts under the common law, which the British had created. It's only in the English-speaking world. The common law is the law of free men. It's what happens when courts apply the demands of the Ten Commandments. That's really where it came from, to real life situations. And they created a law of contracts, a law of property, a law of torts, which deals with how people are compensated when other people harm them. A tort is a civil wrong. And there's also the criminal law. The criminal law came from the Ten Commandments. Each of the actual crimes, things like burglary, crimes against people and against property. It was recognized that people and their property are sovereign in this country. We had a form of real estate ownership, which had been developed by the British over many centuries. It's called fee simple absolute ownership, in which the person who owns the real estate, it's his castle. No one's allowed to invade it. He's not allowed to be sued by, say, environmentalists. If he wants to make a change to his property, it's his property. And it's recognized that the best steward of someone's property for the environment, if you want to look at it that way, is the owner. All these fires that take place in California primarily, but also in New Mexico, they're all primarily in western states. They all begin on one place and one place alone, on state or federal owned lands. Because when property is owned by the government, it's not owned by anybody. Politicians and bureaucrats are put in charge of it, but it's called the tragedy of the commons, where when property is owned by a particular person, he takes care of it. It's the old joke of nobody ever takes a rental car to a car wash. They don't own the car, so they don't have any incentive to do that. People who own it do. And it's the same principle. All of those fires take place on public lands, or they begin there. That's not necessarily where they end. They can end up burning down people's houses and burning down private forests, although they rarely do. There are millions and millions of acres of private forests in this country. There's not a single fire of any magnitude that starts on any of them, because the people who own those forests know how to run them. And they are actually barred by crazy environmental rules from even telling the federal government how to run its land. That's why all these fires take place. That's just an example of what happens when the government gets in charge of property. When the government's in charge of property, no one is really in charge. And when no one's in charge, there's no one to blame, which is the way bureaucracies, it's one of the ways bureaucracies obtain power over people. They all point the finger at somebody else. Like when Fauci was telling everyone to do all that stuff during COVID. He said, oh, I'm not to blame. That was the politicians. They were just following suggestions I made, and I made suggestions that were all over the park. That's what bureaucrats do. He's a classic example of a bureaucrat. Anyway, bureaucracy itself is a strangulating thing, and it is a way for the government to obtain power over us. And politicians and bureaucrats love expanding the power of government. The founders recognized that that's what politicians would try to do, and they made it very difficult for them to do it. It took a long time. For example, one of the ways that they've enhanced their power is by the creation of the federal bureaucracies. During the 19th century, there were very few federal employees. There was constant fighting, particularly, it began with Jefferson, about how to pick the people who had public offices but who were not elected officials, like senators or the president. bureaucrats, how to pick them. On the one hand, politicians wanted to put in their buddies, people who contributed to them. And doing that, having politicians pick their own people for those appointed offices, was given a bad name, particularly during the Jackson administration. They call it the spoils system. To the victor goes the spoils. Now, Jackson said it was a good thing, and he was right, because it's very important that the elected officials who are in charge of each department be the ones who run it, so you don't have faceless, nameless bureaucrats in charge of things who answer to no one. They have to answer to someone, and unless they're serving the interests of the person who for example, if the president can't control who is in the federal bureaucracy, he has no control over them. And under the Constitution, in Article 2, it establishes the executive branch. The president, and the president alone, is the executive branch. It literally says that. The vice president, until the vice president obtains power as a result of the incapacity or death of the president, the vice president actually has no constitutional powers whatsoever. The president has all kinds of powers. They're all described there, over the military. Anyway, and Congress has powers. They're described in Article 1, Section 8. But it's only the elected officials in Congress who have those powers. And the only power that Congress has is specified in the first few words of Article 1 of the Constitution. All legislative power, all, shall be vested in the Congress. And it then goes on to tell how you pick these people. Very, very strict rules about how they get picked and when they get picked, and the fact that their terms of office only last a certain amount of time. People who have had offices in the Congress and is the president are not allowed to have power over us after they leave office. But one of the very important ways that those people have been having their power over us, even after they're gone, there's two ways they do it. One is the filibuster rule, which makes it impossible. It requires 60 votes in the Senate. It's clearly unconstitutional. Senate is always supposed to rule by majority rule. That's the way republics are supposed to operate. The officials who get elected are elected by a majority of whoever is electing them, and the elected officials have to vote by majority rule. That's the way a republic works, because when a supermajority is required, that gives the minority a veto over the majority, and that's never supposed to happen, except in very rare circumstances, and our Constitution specifies certain circumstances where supermajorities are required by the Senate. But what the filibuster rule does, it takes those exceptions to the rule and makes them the general rule. Everything, except for very few things, has to be passed by 60 votes. That's why President Trump and the Congress turned themselves inside out with that so-called one big beautiful bill. They had to stuff everything in there because that bill was created pursuant to a procedure which these people have created, which is an exception to the filibuster rule. It's the one procedure under which the majority rule works in the Senate. And that's the only way a republic is supposed to operate. And by having the filibuster rule there, they're not allowed to repeal prior legislation except under the filibuster rule if they can get 60 votes. So the minority gets to veto the majority from repealing stuff. And that's how stuff never gets repealed. So that once it's been passed, it's there forever. And they create these agencies that are there forever. Now, the agencies themselves are unconstitutional. There were none of them, by the way. We didn't have a single one of those federal agencies, other than the Department of State, which was very small in those days, the Department of Treasury, also very small, Department of War, and there was an Attorney General, but he didn't have any Justice Department until 1870. That's when there was a Justice Department. So the entire quote-unquote Justice Department of the federal government until 1870 was the Attorney General. Now, if cases came up, he could hire outside lawyers to handle them. But it was a very limited role. The federal government was not supposed to be involved in doing a lot of prosecutions or lawsuits against the citizens. That was not supposed, they weren't supposed to be in the business of policing us at all, because there was an entire body of law that had been created. I told you about it earlier. In the common law, the common law is something that each state had, and it was virtually the same in every state because they got it from the British. And that was the law that was supposed to be used to police us from harming each other. That's the only law. So that this notion, people like Elizabeth Warren say, oh, if we don't have these agencies dictating how businesses operate, then it's the Wild West. That's a complete lie. Under the common law, there are things called business torts, things like the tort of fraud or nuisance. If a business creates a nuisance, or an individual with his property creates a nuisance harming other people's property, those other people can sue him. But environmentalists who don't own any property right there, they can't sue him. That's all been created by statute, and those statutes are unconstitutional because they directly violate fee simple absolute ownership of the property by the owners. And the owners are supposed to be able to do anything they want with it as long as it doesn't create a nuisance. And if they have plans for the property that's going to create a nuisance, there's two different types. There's both public and private nuisances. If it's going to do that, people that are actually going to be harmed by that can bring a lawsuit against them to get an injunction to have a court tell them they can't do it. But only in that situation is the owner forbidden to do that. Anyway, the big ways that the federal government gets away with expanding its power, and by the way, whenever it expands the power of the federal government, that means it's giving it to politicians and bureaucrats, because they're the ones. It's not just the impersonal government that has this power. It's people in office who are able to use the levers of power they get from the government over their fellow citizens. One way they do it is with the filibuster rule. That keeps everything in place. They can't repeal anything. Another way is by creating these bureaucracies. And by the way, during the 19th century, there were various pieces of legislation passed. Ultimately, in I think it was 1873, there was something like the Civil Service Act, which created this. It was during the Progressive era, the beginning of it, and then it got expanded, creating this notion of these brilliant civil servants who were supposed to be experts in their field, and they were picked on the basis of merit, not on the basis that the politicians in office wanted them. Directly contrary to our Constitution, really, because the politicians are the only ones elected by the people. So if people are working for them and they're in agencies under their control, and they have to be under their control. If they're not under their control, they're under nobody's control, and that's never supposed to happen in a republic. In a republic, the people are supposed to have control by voting for the people in office, and the people in office are supposed to have control over any officials who are not elected by the people. That's the way it's supposed to work. And by creating this whole notion of meritocracy in the civil service, where they also made it impossible to hire and fire people, that was all an intrusion on the power of the president, but also on the legislative branch, because they began to create concepts like having contracts with these people. So these people have rights. They're not supposed to have rights. The citizens are supposed to have rights. They're supposed to be our servants, and they're supposed to have to answer to the president if they're in the executive branch. And of course, the legislative branch has set up its own bureaucracies, and it's empowered them with all sorts of legislation. One of the things that they've done is they have handcuffed what present-day Congresses can do about the budget. They've got statutes that have been passed by previous Congresses who are no longer in power, with all these rules about budgets, about what can be paid, completely unconstitutional. The power of the purse is supposed to be in the present Congress and the present Congress alone. And they're allowed to make the rules about it, and for now, because another Congress can change it. But past Congresses are not supposed to be able to control it. There's a thing called the dead hand rule. This is part of our Constitution. It's part of the unwritten Constitution. under which, and that's what it basically says. It's been recognized by the U.S. Supreme Court in a case called Windstar, that past Congresses cannot control the present Congresses. So all of that legislation that's been passed by previous Congresses that handcuffs the present Congress is completely unconstitutional. They can't write statutes that have that effect of preventing the present Congress from passing whatever budgets it wants. They can't give them rules for that, and they can't set up these bureaucracies that can't be repealed because of the filibuster rule. Basically all of those things which they've used to entrench all this power of the people in the federal government over us, it's all unconstitutional. The filibuster rule, the creation of these bureaucracies with all that power, and the existing legislation which binds the hands of the existing Congress. And by the way, when it looks like, when you have something like the filibuster rule, which seems to limit their power, in fact, it increases it. What it does is it increases the power of the minority, because the minority can demand payment for anything it agrees to. And that's exactly what they do. And the founders recognized this. They wrote about this in the Federalist, which the Federalists were essays written primarily by Alexander Hamilton and James Madison, the two principal. Madison was the principal literary author of the Constitution. They were done contemporaneously in 1788 and 1789 to describe what's in the Constitution and to tell people why they should adopt the Constitution, which was written in 1787. And that's the importance of those documents. They're literally the Bible on what each of the clauses in the Constitution means. Cases by the Supreme Court interpreting the Constitution are of nowhere near that same value, because they're not by the contemporaneous authors. These were statements by the authors of what they meant. And every one of those administrative agencies has been created. The Supreme Court has used one clause and one clause alone to authorize them, the Interstate Commerce Clause. And as I've said in multiple videos, that clause in the Federalist 42, where Madison describes why that clause was put in there and what it means, it doesn't permit any of those agencies. The federal government is not allowed to be policing the citizens of the country except in very limited ways. And they actually gave the only crimes. It's right in Article 1, Section 8 of the Constitution. The only crimes the federal government is allowed to prosecute are the crimes of piracy, but only piracy on the high seas. It specifies that. So that if the pirates come into Savannah and require people to make bribe payments to walk down the street, that's a Georgia problem. Federal government's not allowed to stick its nose into that at all. So piracy on the high seas and counterfeiting. And counterfeiting is the unlawful printing of money. Guess who does that every day? The Federal Reserve. The Federal Reserve didn't exist until 1913. It's a blatantly unconstitutional agency. When they created that, they nationalized our currency. Prior to the Federal Reserve, all the paper, we had paper money, and it was perfectly good. In fact, it never had a cent of inflation the entire time, from 1789 until 1913. Not 1 cent of inflation. And it was all printed by private banks, backed by gold. You could take the money to that bank, and they'd have to give you that amount of gold. They had to keep gold on hand to do this. And that's the way our system was set up. And we never had the booms and busts that we've had since the creation of the Fed. It's been a disaster. The founders were smart not to have the Fed, and they knew they only gave the federal government the power to coin money, not to print it. Very specific. They're allowed to coin money, and they put that into Article 1, Section 8, because they knew all about paper money by central governments, because the French had done it earlier in that same century, and they knew all about it. And that was the last thing they wanted the federal government to be doing, and the federal government didn't have the nerve to do it until 1913. Anyway, I'm Cliff Ribner, and if you like this video, please show that you like it by liking it, and tell other people about my videos, and watch them on my YouTube channel, and they're also at my website, cliffordribner.com, and so is my book, which I think you'll enjoy if you like my videos. Thank you.